I'd like to welcome everyone. This is the second edition of Lisbon Law and Tech, an international conference hosted by the Knowledge Institute of Abreu Advogados. My name is Lloyd Xavier, and I'm head of Knowledge Institute and consul at Abreu Advogados. I teach law of artificial intelligence and private international law at Católica Law School. This week we had the opportunity of discussing hot topics such as online courts, interfaces between law and design, and global trends and regulation of artificial intelligence. For this closing session of Lisbon Law and Tech, we have the privilege of approaching the concept of legal engineering with one of the pioneers of legal tech, Joshua Walker, the author of an amazing book on legal AI. And Joshua has studied in Harvard and Chicago. He has worked for the International Criminal Tribunal at Rwanda. He has worked for large law firms in Silicon Valley, assisting major tech companies with complex M&A and IP litigation problems. He is the co-founder of CodeX, the famous Stanford Center for Legal Informatics, the first law and computer lab in the US. He has worked as a lawyer for Facebook when Facebook was a social network startup. He was the founder and CEO of Machina, the first legal analytics company spin-off of Stanford Law. He has supported the US judiciary and the White House Office of Science and Technology Policy with patent litigation data. He has done important work in the area of AI and financial regulation for the UK Financial Conduct Authority. And he is currently the Chief Product Officer at Aon IP Solutions. So, Joshua, it's a great honor to have you among us, and the floor is yours.
Thank you so much, Louise, and thank you so much to the Knowledge Institute and your firm and the university in general, the Global Institute. I'm delighted to be here, and the honor is mine. So thank you so much for the opportunity, and to be here even virtually in Lisbon is a treasure. Our topic today is called on, and by the way, I encourage people to ask and iterate on this, and then even afterwards, would love to hear questions and listen as much as talk. But for now, I'll give a brief chat. The talk is called on legal engineering, but given the context in Lisbon, it should easily just be called the age of exploration, because I think that's what we're in. This is an exploratory age. And some of the themes you'll find from that period are quite relevant to us, and some of the responsibilities as well. The end goal of today and this brief little talk is to think about change management and tradition management as well, because change is not necessarily good in and of itself. It's how do we help our clients using some of the new technologies that are out there? What's the context for it? And how do you practically apply it in things like litigation and contract, AI and M&A? How do you help clients with this? How do you help the poor with this? How do you help people without access? And how do you help clients in general? So I've been doing the same thing really since I was about 15, but I've done it in very different spaces in different organizations. Which will reflect, probably most of the places that people are in, whether they're a student, whether they're a judge, a judicial clerk, whether they're in government or law firm attorneys, right? Which is most of us a lot of the time. So I'm going to talk a little bit about that. I'll share a little bit of the story, and then we're going to go into questions and how we takeaways from each of these perspectives. And again, it's a little bit personal, but I know these stories well, so hopefully they're useful and can be reapplied, just like case law in the common law. When I was, in college, probably before a lot of the students anyway on this presentation were born, there was a genocide in Europe. It was the Yugoslav genocide. Yugoslavia was, of course, controlled by a strongman. When Tito died, the country, though it was, very peaceful through that sort of one personality, it disintegrated. And they were starting in Vukovar in northern Croatia. There was a genocide that began, and the former Yugoslav National Army was very involved as well. And there were a lot of atrocities committed. And like a lot of people, when I read about these things in the paper, I was very angered by them. I was very upset by them. And I went there as a student in about 93, 94. Which is not a smart thing to do at all. Go as a student. It wasn't that dangerous, but still probably not wise. And I actually met just a lot of people that had been outside or that were trying to contain the conflict. Anyway, when I was still an undergraduate, and as you know, in the US, it's a two-tier system. So you have to go to undergraduate degree first, and then you get your graduate degree in law, if that's what you want to do. And I had snuck in as an undergraduate student to this, what do you want to do with your life type presentation that a lawyer was giving. And she was named Crystal Nix, an amazing attorney who was working at the State Department in the US. And I heard her story about how she was working on human rights and how she was working with some of the new tribunals. And war crimes tribunals were a very new idea at the time. And I basically bugged her for a year until she gave me a job. I just very, very politely annoyed this one person. I said, you've got the Yugoslav tribunal, you've got other things going on, and you need not just lawyers, because I wasn't a lawyer yet, you need people to manage the data and support and paralegals and case managers and analysts. So eventually she calls me up and she says, I don't have, I know you do Yugoslavia, but I have an opening in Rwanda. And so I leapt at the chance, went to DC, and then I ended up in Kigali, Rwanda. And it was a pretty intense experience. And so I was eventually deployed to the national team, which was looking into selective killings, murders by a very select group of people, national people that have been targeted. The military, how the military had actually orchestrated a lot of the military operations in the genocide in Rwanda. And just for your background, about 1 million people were killed in Rwanda alone. Very traumatized country. But the problem we had with all of this is the only way we had to access data was looking at basically photographs of documents on a real system. I know this sounds ancient, but I think they're still around, called microfiche. And we had, a small data set, 2 million pages of documents, but to scroll through them like this was going to take a long time. It was not usable data for the investigators and the prosecutors and things like that. This is very early on, 96, 97. And so we had to build a database from scratch. And this is actually a really important story for us because it doesn't involve technology, really. It involves organizing data. And whenever you hear the word AI, be a little aware that all that really means is applied mathematics and data. That's all it really means. And you don't even have to understand all of the mathematics of it to understand that you can make use of these types of things, as you do every day with internet search and things like that, but in a very direct way with legal process. So we had no database that worked, and the one that was designed wasn't what we needed in the first place. And despite a lot of amazing people, we couldn't, the tribunal was funded, but we couldn't get access to the funds very easily. So, my mother was sending me legal pads from Canada, and my other friends from the US, American as well. And my American friends were giving me advice about what to do, but on non-confidential basis and things. And so we had to build a database from scratch. And I worked for this, we had a judge who was a team leader named Matar Diop from Senegal, and an Australian crown prosecutor / cop, he was more of a cop persona, named Michael Hurrigan. Together, they divided the genocide and our investigation into 21 parts. They assigned 2 investigators, 2 very senior police people, usually from all over the world, to each element of the genocide. And this is, again, not private information right now. And those two people, each of them, usually they were from very different backgrounds, typically one from Africa and then one from Europe, Canada, the US, and they had very complementary, kind of backgrounds typically. And it was those people were the best managers I've ever seen. They were incredible. And but originally Michael wanted me to photocopy every single document in the system and then create binders to do all this. Of course, as you know, as the younger folks, this would take forever and probably would be, we'd still be photocopying if I was going to be doing that. So instead, we built a database using Word. We just organized all our, basically the 21 different parts of the investigation. We created categories, master document, subdocument. It was very simple. There was essentially almost no technology to it, but it's still one of the best databases I've ever seen. Why was that? Because the data system we created, and it's been fully searchable, very fast to put in data into, and it worked for what we needed until a bigger database system came online. It was isomorphic. The database, the structure we were creating was exactly matching to the investigation we had to have, which exactly matched to the elements of proof that the prosecutors need to create, which exactly matched to how do we help the victims of this genocide, right? And so helping that and being humble enough to see that the technology is of secondary importance, the client's goal is of first importance. That's a theme that you have to be thinking about every single time you hear the word AI or legal AI or computer science. How do you leverage this to get your client's objective? And it's not who's the fanciest, it's not who's the best, it's who is the humblest and who has their hands in the data to make things successful. Anyway, I came back home. It was difficult for a while. We were doing it was a very intense experience, and I feel very thankful for it. But it was quite intense, and it takes a while to kind of reintegrate back into society, if you will. If you've been living overseas, and you're involved in something that no one at home had any idea what it was. Like, no one could relate to kind of the things that had happened. So that was tricky. I ended up at the University of Chicago Law School, and when I was an undergraduate, again, you're undergraduate. I majored in conflict studies. I created a concentration to do what I was doing in my first job, and law school was later. As an undergrad, I had avoided economics like the plague because it was there was like 500 to 1,000 people every class, and for some universities that's not a lot, but for me it felt like you're one of cattle that was being processed through the thing. There's too many people. It was they called it the dismal science. So I didn't do any of that. And as punishment, God sent me to the University of Chicago, which is an incredible place, by the way. It's not a punishment to go there, but it just shows you how the arrogance of youth can be corrected. I learned about economics. Chicago is a very L&E driven place. It's well known for the law and economics place, and have amazing teachers there, and students, very small. And I fell in love with mathematics, and I had some great teachers in high school, but very few of them were. Most of my teachers in math were coaches. They had other passions. Geometry was not their biggest love in life, perhaps. And so I discovered math in law school, and it was probably a good sequence. And learned about risk management, corporate finance, things like that. And it was very strange. Anyway, 9/11 happened when I was in school, and the idea of being an international criminal law prosecutor was, despite having great connections and friends and work experience there, became very difficult for an American to work in The Hague or something like that for political reasons. So that is what it was. So I went to Silicon Valley, and I knew I wanted to do something in law and computer science, but not what. And the market was crashing. It was 2001. And all this kind of, the first new internet companies, most of them flamed out and died. Grocery delivery was a big thing back then, and it failed for various reasons. It was a little too early, perhaps. Now it's obviously enormous. And all of my friends were fleeing to safe jobs on Wall Street or at Lehman Brothers or, back in Chicago. And I stayed at a very big firm, an amazing firm called Skadden Arps in Palo Alto. He worked for a guy named Ken King, his other partners. Great experience. But again, you're a first year student and you're a first year, associate. You're starting from nothing. And I was very fortunate, but I was also very bored too, because I thought, the tech checks, grammar checks, and things like that we were doing for big internet companies, private equity firms, they were very important. And if you mess them up, if you mess up the signature page to a $10 billion deal, it's very, very, very bad, right? So you have to be perfect. You have to be perfect in, if someone's IPO filing has grammatical errors in it, people tend to just distrust the numbers in it and the content. So everything, the sort of perfectionist drive was important, but I also thought robots should be doing a lot of what I was doing. And there was a lot of important things as well analytic, but robots should be doing a lot of it too. And I had one client, it was maybe a first or second year, a European company was buying a Palo Alto company, was in software. And in many of these M&A situations, you have change of control provisions. So if the company is purchased by someone else, all of their licenses to access data and other pieces of software disappear or potentially disappear, right, once the transaction is closed. So they need consents. So we had lost one of those consent rights because of a change of control provision. The client asked me, perhaps unwisely, the client put me, I was allowed to talk to the clients then. He said, "What's my risk? What's my risk?" He was a business person, not a lawyer. And so not knowing any better, I sort of came up with a formula for, well, here's the risk they might sue you, and here's the risk you lose the right to do this downstream in your software product, yada, yada, yada. And the client was very happy with that. He's like, "I get it, that's cool." And I said to myself, gee, it'd be nice if I could put some data into this kind of formula, right? It wasn't Black-Scholes formula, but it was just a way of framing the legal risk for a non-lawyer. Anyway, fast forward, I was, as Lise mentioned, I was litigating a little bit later. I wanted to do more IP and litigation stuff, and had an opportunity to do that. We started CodeX in about, I want to say, began in like 2002, 2003. I was about to go to MIT to try to learn how to do software coding, and the only two computer scientists who were interested in law at all that I could find in the US, Holland, Italy, other places were thinking about this long before us. And there was a very rich legal tradition with Richard Susskind and other people at Stanford, but nobody in the Stanford computer science department was interested in law except the logic guy. And if you know about CS, the logic people and the machine learning, statistical AI people were very different. Logic was not the most popular thing back then. It is now, especially combining it with statistical methods and things like that. That is very, very popular now. Back then, it was a little bit it was considered old-fashioned, so shall we say. And the way that they programmed using Prolog and Lisp and things like that, before Python took over and really took off, which is very similar high-level language, it was very unpopular, right? So, but the logic people, both at MIT and Stanford, were interested in this topic. Even though the life of the law, as Cardozo said, is not all logic per se, sometimes it's analogical. So he said, no, don't go to MIT, well let's give a little talk. I met with my friends Roland Vogel, who's now the head of CodeX, Michael Genezareth, and his student Nat Love, who was a CS PhD student, went on to clerk for Judge Posner, was one of my teachers at Chicago, and was glad to help ensure that he got there and is a practicing lawyer now. So there were very specific people that were working on this, and thankfully, two professors in the law school, Mark Lemley and Peggy Radin, said, okay, we'll let you do this project. Fast forward, and I know I'm probably getting too much detail here. Fast forward a little bit to the CS department. I had a chance to work for a tiny little startup called the Facebook.com. And I said, And it was a great case. I was the only associate working on it at the time. I'm not going to talk about the case at all, obviously, but I will say I loved being in the data and just reading it and trying to help our client, trying to knock out, thank goodness, opposing claims that we got in some of these, it was a Harvard controversy, strangely enough, some of these cases, and it was a privilege. But I also said, I'm such a loser with my life. Even then they had 200,000 users, and without endorsing everything that happened since, I said, I could see that they were going to be changing the world. They had an opportunity to do that. What was I doing with my life, right? And my friend Roland calls me up and said, hey, we're starting this new database project. And we've analyzed securities class action lawsuits in the US before. There's about 250 of those a year. And 250 of those a year, and it's all public data. I'm going to do the same thing for intellectual property. And I thought to myself, sounds boring, doomed to fail. The reason it sounds doomed to fail was that antitrust and intellectual property cases, unlike those corporate securities cases, there's about 100,000 cases you'll need to go through. All the settlements are secret, pretty much, except unless they're material to a public company, which is very rare. And there's just so much data. Any one of those cases can have 9,000 different docket events, things that happen in the court. And any one of those events can be a $500,000 summary judgment motion. That's going to take a lot to go through. So, but then I thought to myself, this is a database. It's a chance to do something that's going to help a lot of people, even though it's not as important as war crimes prosecution. And I said, this is something I should be involved with. Applied for the job, thank goodness was able to get that, and took a massive pay cut to go do this project and read through about every single patent trial and case in the basement. That's another thing. You have to spend the time in the basement with the data, you or your colleagues or your associate. So I spent 2 years just coding cases, really, and then going across campus to convince the CS people that, hey, I know you hate lawyers, and not really hate, but no one wanted to. We were considered outcasts would be a kind word for the CS and engineering department at the time. But after 4 times, and after I think one CS professor was thinking about calling the police, he was 50-50 on it. I hired one of his best students, and then said, okay, we'll do this. And that was a very generous computer scientist named Chris, who's one of the top NLP people involved. The other computer scientist was Andrew Ng, who was fortunately also able to help us down the road. Andrew is now one of the most famous machine learning and AI educators in the world right now, starting Coursera and other things. So really amazing people that gave their time to patent law. Sometimes because they didn't like patents over software, but it was a very important step. It was Stanford, so of course people started thinking about how do we spin this out. And the reason we had to spin it out is to retain, especially back then, world-class engineers. You couldn't do it in law school. World-class AI engineers just did not want to work at a law school, but they might work for a startup that was having a positive impact on society. But when we spun it out, their mission was very clear. We had to. I made sure that we were legally required, and Mark Lemley, who was the progenitor of this project, who raised $5 million to do it, he was very clear about that as well. All judges, all clerks, all full-time, all government employees, and this is not just the US, it's all over the world, had access to the most advanced technology. It was in our charter of the organization, we had to do this. And anyway, long story short, there was another recession going on, so we launched in the middle of the 2008-2009 recession. And thank goodness it worked. And we just kept at it. Many things should have killed us. There were originally US charges for data. So we had no way of paying for all the data. So we had to win a big battle in the US court system to get access to it. Not every judge wanted their data available. But here is what ultimately happened. I know we're short of time, so I'll cut to the chase. By making data available, and I had to go out and talk to every spectrum of the political world around IP, people that loved patents, people that hated patents, people thought that software patents shouldn't exist, people thought they were very pro-software patent. Everyone thought I was going to be on one side because the professor was on one side. And I assured them I had no religious beliefs about IP. I just want to show people the data. And what we found in the system was that a lot of the politics around this were just completely wrong. But what we found is the US was terrible, terrible about issuing software patents. 95% of the patents in court, which is 37,000 patents about at the time versus the millions that exist, of those software patents, 95% had something fundamental knocked out as invalid by the US judges. So you can think about a factory where 95% of your product gets invalidated as something seriously wrong and recalled. That's a problem. Even though justice is not a widget, it's not a tool, it's not an automobile, however complex it is, it's way more complicated, way more esoteric. Understanding empirical data is critical. And what we couldn't do, and this goes back to the mission, that what we couldn't do is the federal judge, Judge Vaughn Walker, chief judge in Silicon Valley in the Bay Area, Northern California, he was able to give us access when we were still a startup. Sorry, before we were a startup as part of Stanford, and with the blessing of the Chief Justice of the US Supreme Court, he gave us access to his habeas, all his docket, right? All the public elements of his docket we had access to. But we didn't have the funding of the mandate to analyze the criminal law cases and the habeas corpus, which are prisoners who say my rights are being denied. Habeas is a massive problem because some people are going to die if the judge doesn't help them. They will be killed by gangs. Their health they're actually being wronged. But there's many others that have infinite amounts of time. So there's a lot of these things, not all of these meritorious. It's a huge issue for the federal judges to just find those real cases and handle the others, right, and distinguish between them. So, but having AI, these types of docket management tools that extract out data from the system using humans as well as using AI to scale us, we'll go into what the difference is in those. I think combining the lawyers and the AI can help with all this, but I found some of the most important projects are some of the least funded, some of the least ones to address. But it worked in patent. I think we were able to help give data to the White House, to the federal court system, all the district court judges. My favorite thing to do is train clerks and talk to judges about it, as well as the legislature. Our Senate in particular was very interested in this. And there were legal changes and there were Supreme Court changes in this area, not all because of Lex Machina, but having the data really helped advocates say, here's what's going on, and not having an opinion about the right policy. Here is some data. We're bad at software patents, and some court systems, so they take the same type of cases, the damages awards are 10 times what they are in other types of districts. So we need better damages management. Both those things happen, and they can happen in any area. With that, I know that's probably too much detail, but I wanted to give people a sense of the richness of what is there to explore and the ability to help people that's available in these types of things. Happy to move to questions. You know, the rest of the journey is still ongoing, Luis, but happy to move to questions and talk to people.
Thank you so much, Joshua, for this very, very rich story of how to use data in different contexts to reach an outcome that is very meaningful and useful for different types of clients. I have a few questions, and some of them coming from your book. One of them is I think something that our public would like to hear you about, which is how to assemble, how to put together a successful legal AI project. I know that you have some elements that you consider essential for that purpose. Can you elaborate a bit on your view on those elements that are necessary for putting together an AI legal project?
Yes, so I think this is really important. I'll start with a bit of a, I hope it's not too inappropriate, metaphor, but Frank Lloyd Wright, he was a great architect. I don't know if I'd call him, a Calatrava or, other great Portuguese and Peninsula architects, but, great architect, real visionary. He was once asked in the press how he works, what do you do? And he goes, it's like a cow, say processing food in the field, right? And the idea was he was discouraging further questions about it. One, two, what he was saying is it's not important. I don't want to think about it, and being really self-interested in what you're doing it might help your ego to think that's really important, but it's not going to help your client or your process. And so the one of the dangers that I think I see in this area is innovation theater, where people are, and a lot of times we as lawyers we're told that we must do innovation and we must do it, and clients are looking at the law and they're looking at marketing departments and finance departments and business development and technology and engineering, and they're seeing lots of data and things going around it. So and the legal departments feeling this pressure are pushing their law firms to do change. A lot of that change, some of it's real, right? Some of it's very, very real. But a lot of it is kind of this innovation theater lab stuff. We're doing these things, or we're doing that at this. My question for the lawyers and everyone is, how do you help clients achieve better outcomes? So starting with that, how do you win more engagements by doing that, by being better at helping clients, litigation, corporate, all of that. And there's two different elements to that. One is ignoring the process. How do you actually help them do it? You don't need to necessarily spend money doing this. You may need to think about the data. When I was at Skadden, I probably got the most embarrassing award in history as a lawyer, but a good one for a junior associate, which is most documents reviewed and prepared for a deposition in a 48-hour period, right? So in the data, you got 48 hours and it's a huge data set. How did I do that? I organized the data before I reviewed it. So I did the same exact review, but by processing similar types of things in similar things, I avoided a switching cost, which was going from one there. So instead of legal AI, sometimes we need to think about legal engineering. How do we engineer our process so it's better? The second theme is you will have to convince people that don't believe in data, don't believe the laws should change. And they're partly right, by the way, they're partly right. But for us to maintain our traditions, we have to learn and adapt and get better. We can't be like a fat sprinter on the Olympics, right? We're in the Olympics. This is really important stuff. It can be life or death sometimes, and certainly life and death to companies. And so we need to be the best in the world at what we're doing, or try to be that. And we need to try to help develop the best legal systems in the world to do that. Wherever we are, you could be in Senegal, you could be in Lisbon, you could be in Palo Alto, in the Bay Area where I am, San Francisco. So one is ignore technology while you're thinking about this, right? Understand it, but technology is not the goal. It's a means, it's a tool. And second is, how does this help the client? When I'm doing M&A, when I'm doing litigation, how does this help the client? I'll give an example. Lex Machina is just one example, and I'm thankful to have been involved in it with the great team that we've had. It was eventually a large team, but not at the beginning. But there are two very simple use cases. If I'm pitching it, I had one attorney say to me, "I got a case because of you, because of this tool." And these are partners using a database tool. Very rare, right? They were using it. I said he was going to Georgia to pitch a case and for a judge he knew nothing about, but because he had read all the data in advance, he knew more about what the judge was doing and what was on her docket than even the local lawyers in that district. So he was way ahead of everyone else. So he won business because of that, and he was able to help the client better also because of that too. there is a democratizing effect to having access to some of this intelligence data about what the judge is doing. And that's really important. And when we sold it to that firm, and he was one of my first clients, there was a partner there who's one of the great arbitrator lawyers in the world, like really one of the top arbitration people, brilliant guy, old school. And he's like, I don't need data. And I'm like, I'm not selling you data. I'm selling history. And I said, those who do not know their history may be doomed to repeat it, right? And love that, you know, and it's true. It really is history. If you're going before a judge and she only does this one type of grant for this type of case, don't spend $500,000 of your client's money going after all these other 50 cases. It's most likely a waste unless you have a very good reason, right? Or a big budget and a very good reason. Be focused, understand the element you're in, and try to understand this judge and how she thinks and what the situation is, right? And that's very important. Understanding the history of that became critical to it. And it wasn't, even though it was a bad recession, as another head of a big law firm in Silicon Valley said, if I have it, if my competitor has this, I need to have it, period. That's what drives very rapid innovation and deployment. Like if it's a competitive advantage, that's what's going to drive it. You don't have to worry so much about, you know, convincing people that technology is good. It's like, if you want to win cases, you need to have this. If you want to win business as a result, because lawyers for patent cases, it's a competitive pitch situation and you're competing on price. So you need to know how to price the matter. The only way to do that is using historical data. Another firm is a big M&A firm, and that I haven't mentioned yet, they were using Lex Machina all the time, and I couldn't figure out why. It's like, you're not doing that many patent cases. Why are you using this so much? And they go, every M&A deal we do a search, not just on the target being acquired, but on that field. So if you're buying a small company out of a big company, they may have defensive licenses and thousands or over 10,000 patents that protect them from getting sued. But if you're a private equity firm buying that, you're going to get sued. You have deep pockets, or the perception of that is that you have deep pockets, even though it's an isolated risk. And you don't have all these other thousands of patents and contracts that protect you. So you need to understand how many people file lawsuits in this area, not just how many times a company's been sued. Otherwise, you're not going to do as well on your diligence. We're using it every time, and that's becoming more common too. And using litigation data for corporate and for other things, and for the business, is even better. I'll give you one more use case for this, and we'll keep moving on. We do something called Q of IP. So I've been a flying car lawyer and doing a lot of data AI projects for a big aerospace company, and I'm helping a giant insurance company that is somewhat involved in soccer. I'm not going to bring up football, sorry. Here in present company, that's a very complicated subject. I know, though I play, I don't know enough about. But this giant insurance company, we want to help clients, right? We don't have a need to use technology. We want to help clients. And in M&A, if you're an IP nerd like me, doesn't matter how big the deal is, doesn't matter how techy it is. It was very, very rare, almost never, that IP would be material to the deal. Like it would be very, very important to it, or cyber risk or things like that. Despite the fact that the intangibles in those transactions now that's the most of the cake, right? Is 80% intangible value, know-how, intellectual property, and other things, right? There's accounting standards reasons for that have nothing to do with tech. But look at the S&P 500. Exxon used to be at the top of the list of the most valuable companies in the world, and now it's Microsoft, Amazon, Apple. Like it's technology companies. For me it was business objects back in the day, and similar companies for startups, Google. But M&A hasn't changed, right? We don't have any way of connecting the intangibles value to the value of the business. So we use AI to map the claims, the language, the words and patents to every other single millions and millions of patents. We create customized machine learning tools for this. But the product, it's not the product. The product is called quality of intellectual property. It's analogous to something called quality of earnings, which you do whenever you sell your company. So there's a AI stack down here that's a lot of people that have viewed. In one case, he's viewed over 1 million patents, right? Takes the AI, you have a super duper expert that's taking that AI, managing it, training it to be good for the specific client. It's not generic, it's very specific. And then we write this bespoke 50-page prose and image report. And it's not investment banking, but it's very similar. We are writing text to try to describe very arcane stuff in terms of balance sheets that the investment bankers, the sellers, the buyers, CFOs understand. Translating all this AI stack and this arcana into something that CFOs and business people can understand. That's another example. Client never sees the AI, but it's in that stack. Anyway, I have to talk about why things fail too, but just 2 quick examples about how you can by being in the data, being humble, but leveraging AI to scale yourself can really help clients. And allegedly, according to clients, it's moving the needle for the sell price for clients with interesting IP. So again, not to be too focused on that, but you have to do more than just some AI. It's a huge job, but very powerful when it works.
I'd like to ask you now a different thing. Also a question that comes from my reading of your book, and it's about incorporating legal from the scratch in the designing of a complex system. So of course you talk about the risks of having lawyers apart from engineers and developers, and but how can you convince companies and even startups to involve lawyers and the legal reasoning from the scratch, and how does it create value for the companies?
That's a great question. And when we were trying to convince computer scientists, and again, they said no to everybody, right? They said no to the top tech company. They wanted to focus on what they were doing. So it's very hard to get their time. I think 2 things mattered. One is law is a special environment. Law is an environment where natural language processing actually can work better, in my thesis, because lawyers have a structure to how they write. It's not just generic. It's not just like, as well as there's something called the Wall Street Journal corpus, which is a natural language processing corpus that's available to the world and can be bought or open source. That's well-written prose, but it's not structured like legal writing in the specific context. And the way we structure our legal writing is unique for every country and every system. So the code systems, the way the French write law, the way the Americans write law, the Brits, they're all different. Even British and American law, though they're both common law, and Canadian law, they're quite different from each other. But one of the things we offered was said, NLP it failed a lot. It was not as a serious place because it was just very hard to make it work good enough for a big enterprise. And so he said, law is a special context. Certain, if you want to analyze NDAs, it's a little easier in that space, and you can be more successful as computer scientists in this domain if you're humble about it, right? And if you get the lawyers. The second way to, I think, encourage people is usually they're passionate about something about law. Typically, they dislike something. But if you're a software developer, you know that when someone dislikes something, when there's a pain point, there's friction. It's like grit in the oyster. It will create a pearl if you follow up on it and figure it out. And that was true for Lex Machina too. Our biggest people that attacked our data, we loved them because every time we got a critique from a clerk or a super user or an academic, it helped us get better at what we were doing. And that humility and exposure, the judges attacking our data really helped us get a more useful tool and something that they used it. But when a software person has a passion about patent law, for instance, that can be a very helpful thing, because you can say, look, we don't know what the outcome will be, but if there is an opportunity to improve the system, the data will reveal it. So you have to find people that have some passion about this. People that just sue it as another data site, they probably won't stay for more than 2 or 3 years. But someone who has a passion about the law, they'll stay at it, even if they're not a lawyer. And that was true. We had one of our front-end engineers, our web architect, was a famous, and still is, famous web architect who created a web framework for Python, one of the most popular computer languages. And he created pylons. He was hard to get, but his dad had been sued for patent infringement. His dad was a very famous CTO at a very interesting company. And so he was like, it was torture, right, for them to deal with this. And he said, so he was passionate about it. His mother was also passionate about this area. So you have to find people that have some passion about some area of the law. Maybe it's about injustice. Maybe it's about, are the courts working enough? Maybe it's about getting access to data. All of these things can be very controversial. And you can never have a partisan view about policy in a law company. You can't. You will get killed. Like, it just doesn't. It's not your job to make public policy, but you can improve access to data and let people argue about real things. And for patent law, it's just one small example, but it was like the lobbyists were arguing. It's like trying to rearrange the furniture in the dark. By turning on the light, we could at least argue about real things. And America has not gotten it right yet. We're always going to be working on this and trying to improve it. EU patent law has a lot of advantages to ours for reasons that are about partly about job security and benefits as patent people. But so you're not going to partisanly improve one area of the law, not necessarily, but you can turn on the lights. And so we say in the US, sunlight is amongst the best of disinfectants. So, bad activity, unethical lawyers, all of these things can be illuminated by having access to very, very good data. The reason you need the engineers and lawyers in the room together is that typically, not always, but typically, if it's just the engineers, they'll think of law as just another data thing that they can crank through the machine and it'll spit out something and we'll solve a real problem. Usually those things fail for reasons I can go into. But a lot of it's because lawyers don't have a monopoly on hubris. Engineers have their own hubris too. The problem with the lawyers doing it themselves is, again, we'll die of old age before we produce anything useful. If you have a million different data facets to a problem, which is true in legal informatics, it's true in bioinformatics, it's true of everything, you must use artificial intelligence not to make a legal judgment, but to scale the lawyers and to scale legal judgments. Our systems were not new. They were not making legal categorizations. They were scaling, they were doing a better job than I can do because they learned the history of how I tag things in the basement. 10,000 different things that looked like summary judgment orders. Yes, no, yes, no. Even with unsupervised AI, you have to create the policy and the structure. I was watching recently a project in London called DeepMind and how it beat AlphaGo. And the perception is, oh, this AI is taking over the world. There's a team of 100 Cambridge and Max Planck computer scientists sitting in a room competing against the top, and Google backing them to do it. It's a very human endeavor, even for the most advanced AI in games. It's certainly a more human and domain-specific endeavor, and they had Go experts that were helping them build this AlphaGo system. It's certainly a more human endeavor for law, and what I found worked the best, whether planning, creating, developing, is if you have the lawyers and the engineers in the same room at the same time. We created a new language called expressions to extract information from federal dockets. And the gentleman there is now a senior AI person at Ramesh Malapati at Amazon. So these are really top people, but having great lawyers, and I wasn't a great lawyer, but I tried to be. I was a very diligent lawyer. But having really people that are trying to do the best at what they're doing together, that's a great conversation. Computer science and law, I argue that they're the same thing, because what we're doing is we're classifying information and we're improving process, the algorithms. Same type of thing. And we can port all of that information into the law. So if you offer the computer science types a great opportunity that's intellectually stimulating, that's the thing that's going to draw them in and will keep them in and will help you grow this, flywheel of faster and faster innovation. And you can leverage all of that world. So combining those two different worlds as an explorer, even if you have an incomplete map, that's to me what really draws people in. And we're just at the beginning of that. Did I answer your question, Luis, at all? Sorry for talking too much.
Now, I'd like to move to a different topic, a more general question of regulation versus innovation. Are they allies or enemies in your view in this field?
Yeah, could you ask it one more time, just in terms of how you think about the problem, Luis? I think I've got it, but if you could just
my question is if you view regulation and innovation as allies or enemies.
I think that's a great question, and I think the answer is neither. I think well-crafted regulation is a friend of innovation in law. I also think that innovation can improve regulation. So there's two things to think about for the AI and law example, which is just one small example. One is, how is AI going to be regulated? And the EU may be more focused than the European community, may be more focused, and the UK more focused than the US is on this. We tend to be a little more laissez-faire, but sometimes having really world-class regulators who are focused on this and want to do this as they're incented to do this for their whole life, that is a huge benefit. So you can have very sophisticated regulations of AI. In Silicon Valley, I think the first view of the AI regulatory world is that let's keep the lawyers away. When I was in law school, again, Judge Posner, again, and I don't think he'll mind me mentioning this, but I'll pardon me if it's too blunt. We were talking about, and it was probably half EU people in South America, people in the advanced antitrust class, and half Americans, and so they're very interesting conversations about regulation. And I said, oh, well, you could use a special masters, lawyers, to go into this tech company and help fix certain problems. And he goes, look, to a tech company, lawyers are like a bunch of zombies walking around, killing everything they touch, right? And it was funny. I think it was just a joke, but there's a truth behind that. The president of Stanford, when I was debating him about, law and computer science should be the big thing at Stanford, he goes, lawyers don't get things done. And again, we can push back on that, but there's some truth to it, right? There is some truth to it. It's easy for us as in-house lawyers to say no and to shut things down. It's easy for regulators to be very passionate and just to kill off whole swaths of innovation and be protectionist or not global. And I think it's very dangerous, right? So we're all competing, right? Whether it's as lawyers in our own countries or if we're trying to have the best AI and all these things. And Europe has very, very sophisticated regulators, but how do you create companies that are going to be the best in the world at what they do, right? Or one of the best in the world. I was fortunate to work at Airbus, right? And they're an amazing company. They have amazing engineers from Germany, Portugal, France, of course, and probably well-crafted regulations in some areas. Other areas, it's harder to find those champions. Why is that? Are we over-regulating? Right, and no one has the monopoly on figuring out the best way of regulating, right? In Silicon Valley, sometimes unregulated stuff can get completely out of control, and it creates a pushback. And my argument to the people that don't want lawyers involved in AI is, you will have, and it's old now at this point. I'm saying there's going to be a pushback, and that's unfortunately happened. So the arrogance, the inability of lawyers to regulate at scale inside companies and outside companies has made the top engineers who run a lot of these companies say, keep them away. We're going to do legal ethics, but we're not going to talk legal AI. And the lawyers are like, no, we should shut down this thing and not do this thing, instead of thinking like, how can we be design thinkers and work together? But when we were doing AI projects and flying cars at Airbus, I hid a lawyer on every project team, right? We had to design and launch a flying car that was going to be autonomous in 2 years, right, from scratch. The only way to do that and have maximal compliance was have a lawyer dressed as an engineer, literally camouflaged there the whole time, contributing ideas to have the design of the entire project. And again, managing that is incredibly difficult, but the idea is we need humble lawyers who are trying to help people at the end of the day, help the client get the best outcome. And if you're thinking that way, help citizens get the best outcome, right? With FJV in Sao Paulo, we're talking about the Citizens AI Lab. How can we create AI that helps a regular citizen? Not just the government, not just, things. That's very important. So that's the regulation of AI. I think if lawyers don't learn and adapt, we will get pushed out of this conversation. I think lawyers should lead the AI conversation, but the only way to do it is by thinking about legal engineering. And I'll give you a very specific example, and we can jump to the next thing. The next thing is we need subsystems, legal engineering subsystems for each of these, for a flying car, for a technology, certainly for a website and for AI things. So there's a lot more to your question, but I hope I addressed at least a small part of it.
Thank you very much. Joshua, one last question, and I'd like to quote you on your book again. You say that the general problem is not super intelligence, it's super stupidity. Can you elaborate about this?
Yeah, sure. And by stupidity, I don't mean, deficient in any way. I just mean arrogance usually. And sometimes the cleverest people are also do the dumbest things because we don't think about it. And so with the growth of the internet, and no one thought initially that, there would be computer viruses and there would be people trying to influence election. But it was obvious that would happen. You could predict that people were going to misuse technology. You can predict it. If you sell flamethrowers commercially, you know that some kid is going to get a hold of this thing and he can start a forest fire or something like. So if we know that certain things will get out of control, we know how to regulate them. And I think in terms of technology, and I think that we can predict these things. We've seen it before because we've read the history. That's what lawyers do really well. We understand, here's how things are going to go awry. We have to get the engineers to listen to us. And to do that, we have to be design thinkers. To be design thinkers, we have to think about, what does the client need? The user of your product down the road, how is it going to go off the rails? How do you protect really bad things from happening when it's life and death, right? With transportation, with trains, with airplanes, with flying cars, which are going to happen, right? We have the technology today to do this. The regulation is going to be the most complicated piece right now. So I think that we can predict these things. If you have a lawyer in situ at the design phase of a product, and she or he is thinking about these things, you will have a better product. And that's how we have to think, how to actually help the clients. The last element I would add to that and to the audience is, what's your quest? In Portugal and elsewhere, what's your quest? There is a mission. Because you are here and you're thinking about these things, it makes you a very, very special person. How do you apply it to a very specific problem you're handling it? It doesn't have to be the perfect problem. It has to be specific. And you have to spend the time in the basement thinking about how to actually grapple with that data as well. So anyway, thank you so much, Lise, and happy to follow up after the talk too.
Thank you, Joshua. And it's pleasure to have you on board, and I'd like to thank you for your generosity, because I know that it's very, very early in California right now, and for this closing session, it was the best way to finish our event, our Lisbon Law and Tech. Just a quick word to thank the wonderful work of our team, my colleagues, but also the IT and communication departments, and a final word to Elder Galvão, without whom this event would not be possible. Please follow us on LinkedIn and go to the website at Abreu Advogados, and get ready for the 3rd edition of Lisbon Law and Tech next year. Thank you.
We'll look forward to it, God willing, in person. Thank you so much, Luis, Helder, Alex, to the university and the Institute. Abreu, obrigado.